All right, folks, we are live. Good afternoon. This is Omar Serrata with the Tilted Lawyer podcast. So I thought I was going to be done with the Lively case for a little while at least, and then we get this motion to dismiss, and I'm scrambling to figure out what is this motion to dismiss. I just kind of assumed that it was going to be a motion to dismiss Lively's complaints, and then I was preparing in my head, there's not going to be much merit, there's tribal issues, whatever, more PR stuff. Come to find out, it's Leslie Sloan. Leslie Sloan is the one that files this motion. And her reasons for doing that are essentially pretty basic. I don't think there's a shot in hell that it's going to get granted. She's essentially moving to dismiss based on failure to state facts sufficient to plead certain claims against her, and improperly grouping her into this group of people that conducted a smear campaign against Justin Baldoni. So, to be clear, what we know from the pleadings thus far, these are the allegations against Leslie Sloan, Lively's publicist. She has been accused of seeding stories critical of Justin, allegedly planting stories that Baldoni was a sexual predator ahead of the film's press release. She has been accused of planting an unfavorable story about Baldoni's faith. She has been accused of planting a false story alleging multiple HR complaints, weaponizing the hiring of Tag and Nathan, breaching an agreement with Nathan. Despite an agreement with Melissa Nathan to communicate before speaking to reporters, Sloan allegedly engaged with a Daily Mail reporter and seeded false information to cast Baldoni in a negative light. That was pled. And we've known about that for a long time. That was listed in the complaint, Baldoni's complaint. That was listed, or that would have been around, paragraph 189? There would have been... There was an email attached to that from August 9th, Friday, August 9th. And that was attached to that around paragraph 192. There was, there were sources. She was accused of lying to a reporter after the release of Lively's administrative complaint. She allegedly lies to a Daily Mail reporter to portray Justin as the foe. Also escalated the false narrative by claiming Blake was sexually assaulted, which Lively had not at that time claimed. She, of course, has been accused of orchestrating a smear campaign against Baldoni and his team, working in concert with Jones with the Wayfarer parties since at least August 21st of 2024. She has been alleged to have arranged paparazzi photo shoots and pushing stories. It was alleged that she has a history of leaking sensitive stories to provoke public controversy. She allegedly arranged paparazzi photo shoots and pushed stories about Scientology to sway the public support for Katie Holmes and the Tom Cruise divorce for the purpose of showing that she has a pattern of doing this stuff. She was accused of exploiting Nathan's good faith. She was described as ruthlessly taking advantage of Nathan's good faith, forcing Nathan to combat negative press planted and propagated by Sloan. She was accused of threatening a reporter. She was quoted as saying, "The entire case, I will have to go on the record. This needs to hold." She was accused of denying negative press, allegedly breaching an agreement with Melissa Nathan to communicate before speaking to reporters. She was accused of that's not an allegation, is it? But then, in essence, the allegation is civil conspiracy, defamation, placing people in false light, all as a result of her wayward PR strategies to stem the tide against certain individuals, namely, in this complaint, Justin Baldoni. So this is what she wants to do. Just looking at her complaint, and I'll share it with you all in a minute. Let me just get it up on my screen. Table of contents. Okay, let me get this up on screen so that I can proceed with this. I apologize if I'm not as prepared as I normally am. I'm kind of scrambling to get all of this stuff together within, I had like 45 minutes. I just got out of court. And so, doing my best. Anyway, here's the complaint. So, in her table of contents, you can basically see what she wants to do. She claims that the amended complaint of Justin Baldoni improperly groups her together with others. The complaint must be dismissed due to impermissible group pleading. All right. She also, and these ones really hold no weight. 2, 3, 4, and 5. The amended complaint fails to state a claim for civil extortion, fails to state a claim for defamation, fails to state a claim for sexual. False lights. She asked for attorney fees and costs, and she wants to strike Exhibit A. Well, if she wants to do all of that, this is what she has to do. If we're going to get there, to have a judge grant a motion to dismiss the complaint, this is the legal standard. It's based on her failure to assert claims for civil extortion, defamation, false light. She has to demonstrate that Justin Baldoni has not provided sufficient factual allegations to state a claim that is plausible on its face. And that's a pretty high standard, because if there's anything that is a tribal issue, meaning if it's true, and when you write these complaints, the judge has to take the complaints as if they were true. Like, if all these things were true, do we have a claim? Will this cause of action be actionable? Can we get him for civil extortion, defamation, false light, her rather? And so it's a high bar, because basically, if there's any evidence that they have to dispute, which they're on notice of, that's enough. And they're not dismissing it. They tend to not dismiss complaints. They prefer to have things heard on its merits. So what's the chances that this gets dismissed? I'm just going to go out on a limb without having read the entire thing in its entirety yet. It's slim to none, but I'll see what she has to say. I'm finding out about this about the same time you guys are, and I'm just giving my in real time legal analysis. So she wants to dismiss it. This requires a showing that the complaint lacks enough factual matter to support a plausible claim for relief, rather than merely speculative or conclusory statements. Now, we have seen speculative and conclusory statements. I had opined last night that Blake Lively's amended complaint was full of these speculative and conclusory statements, but there was just enough in there where I stopped short of saying that, oh, they're going to file a motion to dismiss because there's nothing here. It's not that there was nothing there. It's just that a lot of it was speculative and conclusory because it wasn't attached to fact or whatever. And you don't have to attach facts in your complaints. You could rely on simply the presumption of truth in your pleadings. You're pleading it under oath. And if all of the things you're saying are true, then we're going to find him guilty of all these causes of action. That's the standard. It even says the court must accept all well-pleaded factual allegations as true, but is not required to accept legal conclusions presented as factual allegations. The complaint must provide enough detail to give the defendant fair notice of the claims and the grounds upon which they rest. For example, you can't just say, I was sexually harassed. You have to say, by whom? How did he do it? What was the context? What were the circumstances? You just have to basically say that it was enough to meet the elements of the cause of action, and that's it. There's a ton of case law to support that. The Ashcroft versus Iqbal case, that's the classic one that you read in civil procedure law school 1L classes, among others. Federal Rule of Civil Procedure 8, and I'm not going to read all of the other cases. For the motion to dismiss to be impermissible group pleading, which is the second reason why she wants to dismiss this case. She presents it as the first. She has to show that the complaint improperly lumps multiple defendants together without specifying the actions taken by each defendant. In other words, you can't just sue individually every single member of a corporation. You can sue the corporation, But you can't just individually, sue the mail department, the accounting department, the HR department, without stating specifically how they're involved in whatever it is that you're accusing them of doing. There's ways to get around that. If there's some agency there that they were acting as an agent, or somebody was acting as an agent of them under their direction, maybe. But even then, you're still kind of fulfilling the legal requirements by doing that. The complaint must contain sufficient allegations of underlying facts to enable each defendant to defend themselves effectively. And if the complaint relies on vague or generalized allegations against a group of defendants without detailing the specific conduct of each, it may be dismissed for impermissible group pleading. That's Federal Rules of Civil Procedure, Rule 8, as it pertains to the rules of pleading, and there's other cases as well. Regarding her claim for attorney fees and costs, I mean, that's fine. She could do that. Generally, if you bring a motion like this and you prevail, you're going to be awarded attorney fees and costs just by a matter of rule. But the procedural requirements are set forth in Rule 54. It includes filing a motion for attorney fees and related non-taxable expenses, and other things that she has to do. But anyway, that's the meat of it. So let's get into the complaint. That's the legal standard. So it's not enough to say that the complaint was poorly written. It's not enough to say that it was devoid of facts. The standard is this: so long as taking every allegation in your complaint as true, if all those things are true, I could find guilt for all of your causes of action, then we're keeping it in. It doesn't matter how scant the evidence is. The causes of actions all have elements. For example, in defamation, in a defamation claim, you're publishing an untrue statement about somebody, placing them in a negative light, causing damages. You have to plead facts that prove all of those specific elements. If you're missing an element, then you haven't pled facts sufficient to sustain the lawsuit, and you could file a motion to dismiss. And usually what happens is they don't dismiss. They give the moving party the opportunity to amend and cure the what's ailing the lawsuit in the form of an amended complaint. And you get to add additional facts if you can, and you get to try again. They don't just outright dismiss complaints. They give people time to fix things, which is why these civil litigation cases, they take so long. Anyway, I'm not going to read the notice of motion. There was a 2-page notice of motion saying, hey, I and the attorneys representing Leslie Sloan hereby put everybody on notice that we're moving to dismiss Justin Baldoni's amended complaint for reasons. Fine. How did I get all the way down there? So this is their preliminary statement. Let me embiggen this a little bit. Did you guys see that all right on screen? Is it too big? It was too big. That's what she said. How do we get back in? All right, there we go. Is that better? I'm trying to see it on my screen. Yeah, I think that's. So Justin Baldoni has spent years profiting off the feminist and Me Too movements, peddling books, podcasts, TED Talk. This is all the bullshit preamble. Honestly, I wouldn't write it this way. I would just say, look, the way that I would write it is honestly like this. A lawsuit was filed in January. There was an answer to the lawsuits, and an attached cross-complaint naming my client as a defendant. Was later an amended complaint to the complaint. And now that we have the complaint and the amended complaint, we hereby bring this motion to dismiss the claims for failure to state facts that would allow the cause of actions to take hold. Something like that. Sweet, short and sweet. But they write this whole preamble. Like we were commenting yesterday, it's like a PR move. This is not for the judge. The judge doesn't need this. This is all for, they know people are going to read it. They know people are going to make YouTube videos about it. This is for them to say something to the general public. So let's hear what they have to say. Justin Baldoni has spent years profiting off the feminist and Me Too movements, peddling books, podcasts, TED Talks, using slogans about believing survivors, ending victim blaming, and promoting informed consent. His conduct in this dispute is therefore sheer hypocrisy. Beginning conclusory conclusory statements, speculative, all the things that they're accusing them of doing. And continuing with his ongoing campaign to discredit and blame his victims and punish anyone who speaks out against him, the Wayfarer Party's allegations about Blake Lively boiled down to she was too ambitious, too outspoken, and she should have accepted Baldoni's bizarre and abusive practices without complaint, no matter how uncomfortable they made her and other women on set. Other women who have yet to be named. But there was somebody in the comments yesterday that kept on mentioning that, but they said that there are people that are on board and ready to testify and do things. All right, fine. So we will find that out when it comes out in discovery. We just don't know anything about it yet. So all we can do is say, where's the proof? As alleged in Miss Lively's complaint, Baldoni invaded her trailer while she was undressed, improvised kissing scenes without her consent, repeatedly crossed professional boundaries by showing her a video of a naked woman, discussing his pornography addiction, discussing his past sex life, including instances when he did not always listen when women said no. Unfortunately, Miss Lively was not Baldoni's only victim. I will say that this paragraph pretty much sums up way better than anything Baldoni's amended complaint could sum up regarding the specific complaints against Justin. That's a pretty good summation. I mean, when you say it like that, it's like, well, holy shit, what did he do? What do you mean that he went in there uninvited while she was undressing? What do you mean he's showing her pictures of naked women? What do you mean discussing pornography addiction, all these things? Now, in context, obviously, we know that there's some other things going on, and we're not going to rehash all of those. All I'm pointing out is that this was a way better written paragraph than anything I read yesterday with respect to Baldoni's amended complaint. There's some footnotes here, but I'm not going to initially capitalize. For instance, where is footnote number 2? Where did I miss? Oh, here it is. Baldoni does not deny the lion's share of misconduct for which he is accused. I would wholeheartedly disagree with that. He pretty much denies all of it. Well, actually, no, he doesn't. I guess there's a point. Assuming that he actually did discuss pornography addiction, I do remember there was occasions where they would talk about how he was and how he rehabilitated himself and how he got involved in other things and made himself a better man. He's a better man today than he used to be back then, and those kinds of discussions. I do remember that. To the extent that it rises to the level of sexual harassment is the question. And so we'll see. Anyway, he doesn't deny the lion's share of misconduct. Instead, he tries to contextualize his behavior and suggest that Miss Lively asked for it. When Miss Lively bravely spoke up about Baldoni's predatory behavior, I already like this writer way better than that garbage from yesterday. He and his team used every weapon in their arsenal to blame, embarrass, and silence her, going so far as to hire a crisis PR manager who promised to bury Miss Lively and destroy her life. Baldoni also trivializes this dispute about sexual harassment and retaliation by trying to recharacterize it as a mere battle for creative control of the movie It Ends With Us. Baldoni's allegations about the creative issues are irrelevant and tellingly sexist because Miss Lively, an executive producer on the film, dared to offer input on the script, wardrobe, and editing. Baldoni blasts her tyrannical and aggressive, among other coded terms. Now, look, I could go off on a tangent about refuting all of these claims and what I know that Baldoni's going to say, and the way I know that you guys are probably sitting there, all steaming in your pants because you want to say something against what is being said here. I just don't give a shit. This is their preamble. This is their characterization of events. And I've already said plenty against it. I'm just trying to evaluate the motion. So the Wayfarer parties dragged Leslie, Sloan, and Vision PR Inc. into the instant litigation as a smoke and mirrors exercise to distract from their own sexual harassment and systemic retaliation. But the Wayfarer parties never had a Rule 11 basis for accusing Miss Sloan or her company of propagating malicious stories or a smear campaign about the Wayfarer parties. Other than one New York Times article, they cannot plausibly connect to Miss Sloan or her company in any way. The Wayfarer parties do not identify a single malicious story that is part of their intended smear campaign By the Wayfair party's own allegations, all Miss Sloan did was respond to a press inquiry about a story that Baldoni's team seemingly planted. To which I would argue, if Blake Lively is not required to be really specific about the evidence she intends to present supporting all of her allegations, then neither does Justin Baldoni have to reveal all of his cards in the course of litigation. There is discovery. There's things that have been released. There's definitely things that have been released. They're in the form of text messages. Whether or not they rise to the level of anything else is completely different. All I'm saying is, if there are documents, or if there are emails, if there are letters, if there are recordings, if there are other things that are going to come out in the due course of discovery, you're not required to just blast out every single little thing. They were real specific in their timeline. And again, the timeline is not a pleading. That was their characterization of the events based on information they already had that they knew couldn't be disputed. I don't know, and I don't have sufficient recall about every piece of evidence that came out about Leslie Sloan and the communications that she had with others. I just know that there were things that were alleged against her that would cause one to believe that if those things were true, would constitute her part in a civil conspiracy to run a smear campaign against Justin Baldoni. And so there's that. Anyway, where was that with this? Wayfair's own allegations, Miss Sloan. By the Wayfair party's own allegations, all Miss Sloan did was respond to a press inquiry about a story that Baldoni's team seemingly planted. The amended complaint does not and cannot identify anything Miss Sloan did that comes anywhere close to the damning communications between Baldoni and his own publicist concerning an explicit campaign to destroy and bury the woman employees who accused him of sexual harassment. Let me just go back to my notes, because I could have sworn way back in seeding stories critical of Justin Baldoni. There was that, and then there was this other thing, and this other thing came from the pleadings around paragraph 282. Oh yeah, there was an exhibit that was issued. It was in paragraph 281. I can't tell if this was the original complaint or the amended. It must have been the original, where there is a article was deliberately ignores that Lively's publicist Leslie Sloan of Vision PR, once backed by Harvey Weinstein, seeded stories critical of Baldoni, including that Baldoni was a sexual predator ahead of the film's release. Sloan did so even while Nathan attempted to negotiate in good faith. Leslie Sloan says, and then there's an attachment, and then there was other stuff. I'm not going to get into the entire notes. I'm just off the top of my head, just going back through my notes that I have on stuff regarding Leslie Sloan. That was contained in a pleading. And so when they say stuff like there wasn't a single allegation that could be tied to malfeasance on the part of Leslie Sloan supporting the causes of action, I kind of disagree. And that's on the first allegation. There was other stuff, planting unfavorable stories about Baldoni's faith. And we saw that, that would have been around, what is this? Paragraph 101. Meanwhile, Lively's publicist Sloan launches a negative press push against Baldoni. At least as early as August 1st, 2024, TAG was made aware of Sloan planting an unfavorable, false, and defamatory statement about Baldoni's Baha'i faith to page 6. Sloan proceeded to feed false stories to the Daily Mail and the New York Post containing allegations that Baldoni was a sexual predator. Yeah, we're going to have to identify those specifics about what those stories specifically were, what was specifically false. But that, if you're going to give Blake Lively the benefit of the doubt about wait until discovery is over, you got to offer the same to Justin Baldoni. Now, for all I know, I might be glossing over stuff that might have already been contained in a timeline somewhere or in the amended complaint, and I don't have time to go and sift through the 1,000 pages of pleadings to look for it. There's going to be a response. Friedman and his team are going to respond to this in due kind, but I imagine they're just going to simply point to the pleadings and say, well, look, if this is true, we meet the standard, this motion should be dismissed. That's it. That's it, and that is all. So just to address that point really quick, I'm already seeing issues with it. Now, look, it's a motion to dismiss. I'm not sure if it's more geared towards they just want to get a narrative out there for PR purposes. It doesn't seem to me, and I feel like they know that there's enough facts pled that these causes of actions are not getting dismissed. That's why they try to throw in the impermissible grouping thing. I just don't see it holding any weight. The Wayfair parties accuse Ms. Sloan and Vision PR of extortion, but do not and cannot identify where or how the alleged extortion occurred, or how Ms. Sloan or Vision PR Inc. received anything of value because of that extortion. She was getting paid by Blake Lively. Wouldn't that be enough? Where the alleged extortion occurred, how Ms. Sloan and Vision PR, where would that have occurred? Without going into the original pleadings, I'd imagine that Friedman and his team are going to point to instances of Lively refusing to participate in certain things, lest certain information and stories got out about their inability to provide a safe work environment, perhaps fake allegations of sexual harassment that were threatened to come out. There was an entire labyrinth of movement behind the scenes with all of this. It's going to take some time to ferret it all out. Now, look, it's been alleged, but I'll be the first to admit that we need to ferret it out and build a roadmap to how we arrive at extortion. Is it enough to dismiss? And look, I might, for all I know, be completely missing something just because my memory's not that good. But all that is required is they've pled it. They said she's involved in a conspiracy. They kind of highlighted what their method was. You could kind of formulate, if all these things are true, what was in it for her. She was Lively's publicist. They're all on the same team. What would have been the motivation for economic gain? Lively gets the movie credits. She gets to take over the movie. She increases her stature in Hollywood, gets rid of this guy Baldoni, who they didn't like for some reason. Everybody wins. How and why and the who, what, when, where, and why is going to be fleshed out in depositions and discovery and at trial if we ever get that far. The Wayfair parties accused Ms. Sloan and Vision PR of extortion. We read that part. So, factual background. Ms. Sloan is the owner of Vision PR and the renowned longtime publicist of numerous celebrities, including Miss Lively and Ryan Reynolds. She has a decades-long reputation for professionalism and trustworthiness, and the Wayfair party's baseless claims against her have caused her irreparable professional damage and emotional harm. Miss Sloan has never leaked sensitive stories to provoke public controversy on behalf of any clients. And the Wayfair party's attempt to characterize Vision PR Inc. as a Harvey Weinstein-backed PR firm is intentionally misleading. Vision Inc. is entirely unaffiliated with Weinstein, and any stories that the Wayfair parties have planted or encouraged claiming that Ms. Sloan ever worked with Weinstein to attack or discredit his victims are baseless. The Wayfair parties claim that Ms. Sloan initiated the public relations war between the parties and orchestrated a smear campaign against Baldoni, but the amended complaint does not allege any facts to support these inflammatory accusations. But they've also been pled on information and belief. And discovery being ongoing, it's not simply they're not speculating that it happened. They're saying, I'm telling you that it happened, and we're going to figure out exactly how it went down through discovery. It's not the same as alleging sexual harassment and sitting on facts because you don't want to show your cards. It's saying that, look, I know for a fact that you guys were involved in this thing because of all these things exist. Now, we're going to do discovery, and we're going to get to the bottom of all the communications and everything that was going on in the massive labyrinth behind the scenes that was driving Blake Lively's PR team. And that's the kind of stuff that you expect to get exposed in deposition and further discovery. It's not the kind of thing that you would expect to see in text messages, because when you're extorting people, most PR folks are smart enough to know not to put it in writing. So that's going to require a bit of due diligence that I think that the court is going to allow for. And if it comes to pass after full-on discovery that there is no evidence to support, then you'll have a separate motion. It won't be a motion to dismiss for failure to plead correctly. It will be a motion to dismiss on summary judgment that there's no evidence to support the claims, which is a completely different standard. We're just not there yet. We're kind of putting cart before the horse with respect to that. Anyway, Wayfair party claims Sloan initiated public relations. Their own submissions, in fact, prove the opposite. Baldoni's PR team began plotting. They're characterizing stuff. I need to get to the meat. Legal standard. To survive a Rule 12b6 motion dismiss, a complaint must contain sufficient factual matter accepted as true to state a claim to relief that is plausible on its face. That's the Ashcroft versus Iqbal case that I used to hate in civil procedure class in my 1L year. Legal conclusions are not entitled to any assumption of truth, nor are mere recitals of the elements of a cause of action, as you're supposed to do anyway in any kind of a lawsuit. When the claims in a complaint have not crossed the line from conceivable to plausible, the complaint must be dismissed. Bell Atlantic, Corp v. Twombly. I'm having flashbacks. The Wayfair parties assert claims for extortion, defamation, false light, invasion of privacy against Sloan and Vision PR. Each fails for multiple independent reasons. The amended complaint must be dismissed due to impermissible group pleading. So, as a threshold matter, the amended complaint should be dismissed because it is replete with impermissible group pleading and that it generally attributes misconduct to the defendants collectively, while failing to differentiate between the multiple defendants. But I feel like they did a pretty good job of explaining what Sloan's role was in the pleadings. I feel like they did. Each cause of action is asserted by the Wayfair parties collectively against the Lively parties collectively. For example, the defamation claim is asserted against all 5 Lively parties, but do not identify the defamatory statements, much less which Lively parties said them. Miss Sloan cannot be held liable for defamation for statements made by Miss Lively or Mr. Reynolds, but to the extent that she planted false articles that were published, she can. And we're going to have to get to the bottom of what those articles specifically were, for sure. And if I'm missing something, and if anybody in the comment knows what they were referring to by virtue of those false articles, if there's links somewhere that I'm just not remembering off the top of my head, then let me know in the chat, because I don't recall seeing links to specific articles. And they're right. They have to be very specific. What defamatory statements did they make? What did she say? What did she do? You say that she planted stories. What were they? Subject matter, his religion. Subject matter, other stuff. Fine. Where did she do this? Where was it published? Who was the author? We need all these details. I don't know if that's ever been divulged in the pleadings. So to that, I'd have to say, fair points. All right. Back to this. All right, so the e-check. All right. Each cause of action is asserted by the Wayfair parties collectively. I read that. Nor can she be held liable for any allegedly defamatory article published by the New York Times where she did not even serve as a source. That gets kind of iffy, because if you're dropping articles as the manager of a PR campaign, you don't have to write the articles to direct where they go. And now we're getting into agency stuff. It's like if she directed reporters to write stories that were false, that she knew were false. She didn't write the statements. She didn't personally make the statements. She didn't publish the statements, but she put it in motion, which means that the reporters were per se acting as agents of Leslie Sloan. who was acting as a agent of her employer, who were acting as agents of Blake Lively. And that's how you connect the dots and group them all together. They all have their separate individual role in the conspiracy. And remember what I said before I even started reading this thing. You don't have to plead specifically what any individual person actually did, because it's possible that they might have been involved through agency. For example, Leslie Sloan says, this is what we're going to do. I'm going to give you the story. You're going to run with it. And you're going to do it because I say so. Because I am Leslie Sloan, powerful PR director in Hollywood, and I'm bigger than you'll ever be, and I could squash you like a bug. So I'm going to give you this story. You're going to plant it. You're going to publish it tomorrow. It's going to be about how Justin Baldoni is a sexual predator, or whatever they wanted to say. He didn't author the statements. She didn't publish the article. She's not responsible for what was said in the article, but for she put it in motion, which would make her per se, the publisher per se, the agent of Leslie Sloan, who was the agent of the publishing company, who was the agent of Blake Lively, and that's how we connect the dots and get all the way back to the beginning. That's not the same as impermissible grouping. So, all right, so the amending, I see what they're trying to do there, but at the same time, there's distinctions. There's subtle distinctions, and I don't believe that there is merits there, because I believe they're going to bring the agency argument and it's going to prevail. Worst case scenario, the judge says, you know what, I'm just going to give you an opportunity to amend it one more time. What do you think about that? But they're not dismissing this complaint. The amended complaint also lacks a basic mapping of which Wayfarer party is asserting claims against each of the Lively parties. An explanation for the basis of each party's claims is required, as it cannot be that each plaintiff has good faith claims against each defendant. Oh, yes, it can. For instance, there is no viable defamation claim that the Wayfarer parties can assert against Ms. Sloan, because Ms. Sloan is not alleged to have made a single statement. No. But she's alleged to have directed the statements, which is kind of sort of the same thing, let alone a defamatory statement regarding anyone other than Baldoni. Similarly, the Wayfarer parties cannot assert an extortion claim against each of the Lively parties when Miss Sloan is not alleged to have received anything of value from any of the Wayfarer parties, and she did not communicate with anyone other than Nathan. The amended complaint must therefore be dismissed. I disagree with that. So they're going to respond to that, and they're going to make the agency argument, and then this thing is going to be denied, at least on those grounds. Let's see what else she has to say. Failure to state a claim for civil extortion. So the civil extortion claim fails for several reasons. First, civil extortion is not a cognizable claim under New York law. That's actually probably true. They actually call it something else. I don't remember off the top of my head, but civil extortion is not a common cause of action. It's usually fraud or conspiracy or something similar to that. Or just plain old extortion. All right. Claim cases dismissing. All right. Without any analysis whatsoever, the Wayfarer parties assert their claims under California law, merely because Lively has contended that California law applies as to her own affirmative claims. Oh, it's fair. So we're going by California law. We'll give you the California rules. Sloan is saying, I never agreed to the California rules. And so now she's raising the issue. Ms. Sloan and Vision PR do not stipulate to the application of California law as to the claims leveled against them. However, and to determine what law applies, New York courts conduct an interest analysis and apply the law of the state having the greatest interest in the litigation. Here, New York has the greatest interest in the dispute. That's arguable. The Lively parties are all domiciled in New York, and the Wayfarer parties concede that all relevant conduct occurred in New York. That's a fair point. And that they allegedly suffered harm within New York, except if all of the contracts associated with the production of the film and the events leading to this litigation all conceded that California law will control, then California has a greater interest. So fair point on the jurisdictional issue, but if we contract it to say that California law applies, then this argument is over. Wayfarer parties concede that all relevant in New York, okay. Even if New York was to recognize a civil cause of action for extortion, it must be dismissed as impermissibly duplicative of the defamation claim. No, that's not the same thing. Defamation is false statements that are published that cause damages. Extortion is basically the threat of defamation that will cause you damages. Not only is it a civil cause of action, but it's also a crime. The Wayfarer parties do not allege that Ms. Sloan engaged in any wrongful conduct beyond making a handful of statements that the Wayfarer parties claim are defamatory. Their claim, therefore, sounds in defamation, and the Wayfarer parties may not circumvent defamation defenses by styling their claim as some alternative tort. Now, I'm going to cede that I'm not sure if they have enough to prove extortion in this case. I'm not even sure if they have enough to prove defamation in this case. But you don't just get to dismiss the extortion claim, because if what Baldoni is stating is true, and his narrative is essentially, he started a movie, there were contracts, there was understandings at the beginning, but Lively's conduct was unreasonable, and then she started going behind my back in conjunction with other people, namely her PR agency, namely Leslie Sloan, namely Ryan Reynolds, namely whoever else she was associated with that had a role in this. She went behind his back to take him off of the movie, strip him of credits, ruin his good name in the industry, maybe humble him a little bit. Wasn't he the guy that needed to be humbled because it was a little too pompous? He was the guy in Hollywood who wanted to be a leading man standing up for women's rights, a male feminist. Wasn't that the claim? And so we can't rule out extortion, because if a jury decides that, oh, so they're going to make a finding, if a jury makes a finding or believes that Blake Lively withheld her cooperation with the film and threatened through use of her PR manager to publish false narratives about Justin Baldoni, unless he conceded certain contractual points, that is effing extortion. So we're not prepared to separate or lump together the two just yet. I'm not prepared. I don't think the judge would be prepared. I'm certainly not dismissing it. I think we need to see where we're going with this. So, affirmative dismissal, they're talking about case law stuff. All right. Third, that the extortion claim fails regardless of whether the issue is controlled by the law of California or New York, because there are federal courts in California, which indicate that no such cause of action is available under California law unless parties contract for it. Now, I got to go and check back, and I would have to read all of the contracts. There's always a section in there that decides, in the event of litigation, which law controls. They could decide to go by California law. They could agree to go by New York law. They could agree to go by federal law. They could agree to go by Chinese law if they really wanted to, unless there was some equitable reason why they couldn't. And so that doesn't hold a lot of weight with me just on first glance. Yeah, there's other laws. There's other laws that says that things don't work the same way over here. But if you agree to go by a certain set of rules and everybody signs off on it, then we're going by those rules, because it would be ridiculous not to. Fourth, even if the court were to determine that California law applies and follow decisions recognizing a claim for civil extortion under California law, the Wayfarer parties fail to allege the essential elements of the claim. Extortion refers to the obtaining of property from another with his consent. Movie credits, contractual concessions. Just off the top of my head, what else did he give up as a result of having to concede to Lively's demands? I don't know, but we could rattle them off. There's at least two. There are at least two. And those are at least functionally equivalent to obtaining of property. Or some kind of financial advantage, perhaps? I'd have to do the case law research on it, but I'm certain that you could raise that to the level of property to fit this element. Induced by a wrongful use of force or fear or under color of official right. Yeah, the guy has a reputation for being this guy, and you were threatening to expose him as a sexual predator based on what he claims are false allegations. That would place anybody in fear, especially a guy that's positioned himself as he has. California Penal Code 518, which is a criminal statute, by the way, because extortion is in substance a fraud claim. It is subject to the heightened pleading requirements of Federal Rule of Civil Procedure 9B. I agree with this. To satisfy this standard, plaintiffs must allege the who, what, when, where, and how of the misconduct charged. Here, neither element of an extortion claim is alleged with much less with particularity. The Wayfarer parties do not and cannot allege that Miss Sloan or Vision PR Inc. obtained any property from them. Movie credit rights? They were working in concert with Lively? They were working for her? They were working at Lively's direction? Agents of blank Lively? They meet the element. That would be my knee-jerk analysis of that. I'm not even saying that I'm right. I'm just saying that if Miss Sloan and Vision PR were agents of Blake Lively, and Blake Lively directed Miss Sloan and Vision PR to do certain things so that she could get certain concessions from Baldoni and obtain certain credits from the movie, then that meets the property claim. That meets the element. It defeats the claim. This motion to dismiss. Granted, they're going to have to ferret this out. One of two things are going to happen. Either Friedman's team is going to obliterate this motion to dismiss out of the water and ask for their own attorney fees and cost for having to respond to such a stupid motion to dismiss. I'm not even saying that it's stupid. There's things that need to be responded to. There's case law that needs to be ferreted out, but they're going to ask for attorney fees and cost for having to respond and argue the motion in the event that they're successful, for one. For two, they might just say, you know what? Your Honor, I don't want to waste anybody's time. We'll just amend the complaint and add additional facts. I don't think that they're going to go that way. Just seeing how Friedman has operated so far, I think that they're going to go more the route of trying to obliterate this motion and going for the jugular. And frankly, I think that there's probably case law all over the place that justify the pleadings as is. Now, I've sat with this for like 45 minutes, so I haven't done all the research yet. You know what? They're getting paid to do that. I'll let them do that. I'm just giving my knee-jerk legal reactions and how I would think to begin attacking this motion. And then I would spend a couple of hours and I would put it all together and I'd be done, finished. They might have a response ready and published by tomorrow. So, nor do the Wayfarer parties allege that Miss Sloan used force or threats to obtain anything from them. Wrongful use of force, violence, or fear. Well, maybe not force, but certainly threats. I think the entire complaint centered around Justin Baldoni has been that he was fearful that Lively, based on either actual threats or perceived threats, was going to bring false complaints against him. And for a man of his reputation, that was enough to get him to concede significant contractual points. To me, that meets the element. So, in fact, the amended complaint does not allege that Miss Sloan so much as spoke to 6 of the 7 Wayfarer parties: Baldoni, Wayfarer, Jamie, ends with us, Abel, Steve, and in her limited communications with Nathan, Miss Sloan is not alleged to have said anything improper, let alone threatening. Yeah, that's the agency buffer, though, isn't it? So that's not impressive to me as an argument. Point 3, the amended failure to state a claim for defamation. I imagine it's going to be a lot more of the same. Well, I didn't publish anything. I didn't publish any defamatory statements. I didn't do this or that. But the agency argument. So I'm not going to repeat it if that's indeed what it is. Wayfarer party's defamation claim fails on multiple grounds as a threshold issue. Does not and cannot allege that Ms. Sloan made a single statement concerning 6 of the 7 Wayfarer parties. Further, all 3 statements that the whole cast doesn't like Justin, the whole cast hates him, and Blake was sexually assaulted cannot give rise to defamation because they are inactionable opinion or, in the alternative, substantially true. Not alleged to have been made with actual malice and not alleged to have given rise to special damages. To that I will say, if those are if that's the limits of the defamatory statements claimed against her, she may have a point. Because you're allowed to say the whole cast doesn't like Justin and have it be your opinion. You're allowed to say the whole cast hates him. Now, Blake was sexually assaulted as an iffy one. I'm not so sure if you could just throw that out there. That one has some teeth to it. So maybe with respect to these first 2, but this one, I don't know. That seems to me to fit the bill. That would be pretty much the definition of a statement that would rise to the level of defamation if it weren't true. So, all right, the statement that Blake was sexually assaulted cannot give rise to a defamation claim for the additional reasons that this statement is not attributable to Ms. Sloan. And the circumstances of this statement are not alleged with the requisite specificity. I'm just going to repeat the agency argument, except if she directed anybody to publish stories with those allegations into it, knowing that they were false. Then she becomes an agent of the author, and she's already an agent of Blake Lively, and blah, blah, blah. The whole thing. The agency argument. When I say agency argument, just know that what I mean is there is a figurehead at the top that directed this person to direct this person, to direct this person, to direct that person to do something bad. And then they did that certain thing bad. And now we come back and try to sue all of these different people. And then Leslie Sloan, who's like right here, says, I didn't say all that shit. No, but you're part of the chain, so fuck off. Agency. Agency, bitch. Oops. Damn it. Sorry. Please stop it. Okay. So that was that. Ms. Sloan's alleged statements do not concern 6 of the 7 parties. All right. Wayfarer party defamation claim must be dismissed to the extent it is asserted by Wayfarer, Heath, it ends with us, Nathan, Starowitz. It is axiomatic that to state a claim for defamation, the alleged defamatory statement must be of and of concerning the defamation plaintiff. So this part I kind of agree with. If there is no defamatory statements with respect to those 6 cross plaintiffs, I guess is what they would be, or plaintiffs, then the cause of action should be stricken as to them, unless there's a basis to tie them into it. I'm not even sure what that would be. Maybe you'd have to make an agency argument with that. If Justin Baldoni is defamed, then it affects all of us, and therefore we join in this defamation claim of actions because we were damaged by it. That might work. I'd have to dig into that one a little bit further. I'd imagine it's going to be, if they oppose that, it's going to be some kind of an argument like that related to damages. Fair. But if you defame Justin Baldoni, that necessarily affects our movie, which affects our investment, which costs us millions of dollars potentially, and possible millions on top of that in future endeavors. All right. So here, the Wayfarer parties do not even attempt to allege a single statement by Ms. Sloan that is of and concerning 6 of the 7 Wayfarer parties. And by the way, if they whittle this lawsuit down, it doesn't mean the complaint is dismissed. It just means that we're going to whittle down the tribal issues. We're not going to examine whether or not there was a direct defamatory statement placed against Wayfarer. If in this motion they decide, you can't use the agency argument to attach plaintiffs to defamation claims. It's my gut. It is my instinct to say that you probably can, and it would be based on a damages argument. But I would have to flesh that out and do the research and the case law. And like I said, I'm not getting paid to do this shit. They're going to come out with a response, and I will gladly go over and read and analyze their response. I got my own cases to worry about. So there's that. Ms. Sloan's alleged statements are an actionable opinion or, in the alternative, are substantially true. Is this going to be the same thing as the last time? Acceptable context. Yeah, it's the same three statements. I already gave my analysis of that. I'm not going to do it again. Even assuming Ms. Sloan used that phrase outside the context. Oh, let's go to the sexual assault one. Let's see what their argument is. I'm actually curious how they're going to get over this one. So the statement Blake was sexually assaulted amounts to an actionable opinion given the context in which it was made. As noted above, the amended complaint. Interesting that they want to argue context when they were kind of shitting on Justin for defending himself by revealing the context of certain things. As noted above, the amended complaint does not allege what specific words Ms. Sloan may have said to the reporter, what date the conversation occurred, or in what context the allegedly defamatory statement was made. The argument to that is, okay, but when we get her in here in deposition, she's just going to tell us what was said. And then you'll have it on video. You'll have it on candid camera. So why don't you just wait a little bit? There's a subpoena for a defamation that is pending as we speak. Or a subpoena for a deposition that is pending as we speak. All right. To the extent the Wayfarer parties rely entirely on the image capture reproduced at the end of paragraph 193, the phrase sexually assaulted appears to be the reporter's characterization of details included in Lively's administrative complaint, and not any words Ms. Sloan ever said. Maybe she didn't specifically say that, but maybe she said that, yeah, they had this kissing scene, and then he was just being all disgusting with the way that he was going about it and taking like mad liberties and like slobbering all over her, and she didn't consent to that. So do with that information what you may. And how does the reporter do with that information? Justin Baldoni sexually assaulted, and you get the point. That's where we're going with that. Even if Ms. Sloan did use those or similar words, however, where a statement does not appear to be based on any undisclosed facts, but rather offers the speaker's perception of the facts laid out in a public complaint, the statement amounts to an actionable opinion. That may be true. If the statements were authored after the lawsuit was filed, then that seems to be a reasonable argument. I just don't know the date of when that statement was alleged to have occurred. But yeah, if she's commenting on the allegation of a sexual harassment in a public complaint that the whole world is talking about, then I agree. Then that could amount to an actionable opinion, unless other things are proven, which we don't know what's going to come out in these depositions. Clearly, there was people that were spoken to. And clearly, we know what the mechanism of defamation was as it pertains to Sloan. She had conversations with reporters. She threatened reporters. She said specific things and gave specific directives to publish false stories about Justin Baldoni. And so until we get more facts about those things, we at the very least have a framework for, if these things are true, how it happened. Now, they have named, in the same way that Lively has named, that there are others that have had complaints against Justin. They have named individuals who are placeholders without names, who represent people that would have been threatened or directed to give false information at the hand of Sloan's PR company. What we don't have is the specifics. And the question is on this motion is whether or not the framework is enough. I argue that it is. I argue that if those things are true, if the framework is true, then we have enough. But we'll see. Where are we at here? Oh, this is just more. They're going over case law. So even assuming Miss Sloan used that phrase outside the context of discussing Lively's publicly available administrative complaints, and it was not merely summarizing what she read or what others told her, the term sexual assault is insufficiently precise and means different things to different people. No, it effing doesn't. And unless you, well, I concede. To some people, sexual assault could mean a violent grape. To others, sexual assault could mean taking liberties in a kissing scene that was previously choreographed. There are degrees of which people attribute what sexual assault is. But what there's a general consensus in is that it represents sexual malfeasance. And to that regard, I disagree with what they're about to say. That it means different things to different people. Columbia Health, what is sexual assault? Sexual assault can encompass a multitude of forms, such as non-consensual kissing, groping, and or penetration. Courts have been hesitant to apply one definition of a word, and when there is a colloquial meaning, even if there is also a general legal or political definition. There's this case, Miller versus Westlaw, which is, unpublished. But they're using it to make an argument that finding the word terrorist to be a statement of opinion, even when uttered by Attorney General during a press conference release, because the court is not persuaded that defendant intended to use the specific legal definition, and therefore is not convinced that the language at issue has a precise meaning that is readily understood. Fair to that. But with sexual assault, it's different. You have the word assault in there. And I think that if you polled 100 people and asked them, is sexual assault good or bad? They would say bad. I think if you asked 100 people 100 educated people about what sexual assault is, well, I think if you asked 100 people if sexual assault was a crime, 100 of them would say yes. So we might not have a general consensus about what the specific down to the letter definition is, but we certainly know that it is something bad. And like the Supreme Court once said about pornography, I don't know what porn is, but I know it when I see it. I feel like a lot of people feel the same way about sexual assault. Because the text between Nathan and the reporter do not discuss any specific conduct by Baldoni or refer to any specific definition of the phrase sexual assault as used by the reporter, the phrase has no precise meaning. But that kind of makes it worse, because then people are going to go to, it could be penetrative sex. People didn't know that it could be also conspiratorial fat shaming. So there's that. And she did that shit on purpose because she's a PR genius, because she knows how to sway minds of the public. She knew what she was doing when dropping certain hints, and she knew what people would take and run with in the context that she was putting information out there, because she's a PR genius, right? So she doesn't even get to feign ignorance on that issue. Fuck that. Okay. We're done with that argument. And the alternative, Miss Sloan's alleged statements are substantially true. In the alternative, to the extent the court finds that any of Miss Sloan's alleged statements are statements of fact rather than statements of opinion, then the defamation claim fails, because we get it. Truth is a defense. A statement is substantially true when it has the same gist or sting as the truth, or when, even though technically false, it conveyed the same effect as the literal truth. Yeah, but do you even know what that means? Like, you could say that, but, and they cite this example: a plaintiff must plead facts demonstrating lack of substantial truth to survive a motion to dismiss, and affirming dismissal of defamation claim where statements were at least substantially true. Here, the Wayfair parties do not deny the truth of Miss Sloan's alleged statements. That whole cast doesn't like Justin. I'm not sure if Justin ever agreed with that statement. the whole cast hates him. I'd posit a guess that he probably disagrees with that statement too. And he certainly disagrees with the sexual harassment statement. Quite the opposite. The Wayfarer party specifically alleged that the cast sided with Miss Lively. That is not the same as the whole cast, is it? It's certainly not the same as the whole cast hates him, because one might side with one side or the other. Doesn't mean you hate the side you don't agree with. So that's a stupid argument. I'd be embarrassed to write that. Honestly, I'd feel uncomfortable making that argument because I know it doesn't work. The Wayfarer party specifically alleged that the cast sided with Miss Lively, ousted, shunned, iced out Baldoni, and even refused to attend the premiere if Baldoni was present. The truth of that statement relies on pure speculation, conjecture, and hypothetical hearsay statements that we don't even know exist. So, fuck off with that argument. Nor do the Wayfarer parties meaningfully deny the truth of the underlying facts or the alleged statement that Blake was sexually assaulted. For instance, Miss Lively alleges that Baldoni engaged in sexual contact without her consent, including by biting and sucking on her lower lip during a scene in which he improvised numerous kisses on each take. The Wayfarer party do not expressly deny this conduct and merely argue that Baldoni did not need Lively's permission to improvise because he was purportedly in character and that this behavior was apparently acceptable on the show, Jane the Virgin. There was a precedent, there were industry standards, there were nudity writers in place that were not signed but then ultimately signed. There was choreographed kissing scenes, and she claims that he didn't adhere 100% to what was choreographed. She characterizes it as an impermissible sexual assault on her person. He characterizes it as a big misunderstanding and a false allegation for personal gain. That's where we're at with that. You know what that amounts to? Tribal issues. This complaint ain't getting dismissed. But whether Baldoni believes sexual contact without permission is appropriate in the workplace has no bearing on whether Miss Lively consented. He's not arguing that. He's saying that by virtue of working on the movie, understanding what the roles were, having extensive conversations about the scene, leading up to the filming of the scene, having choreographed, gone over nudity writers, gone over expectations and the like, that she per se consented to the production and filming and recording of a kissing scene, to which she was well aware of what was going to happen, and foul play suggesting, because I didn't adhere perfectly to the choreography, because that never works out in any scene that's filmed, she consented to it. That's what he's arguing. Unscripted advances. As noted above, it is implausible that the speaker intended to convey a specific or legal meaning for the phrase sexual assaults. Enough with that already. But if he or she did, Baldoni's unwanted sexual contacts likely fall within New York court's definition of sexual assault, such that the characterization of Lively's allegation is substantially true. That's a stretch, buddy. That is a stretch. This portion of the motion is getting dismissed. As is anything. I don't believe that the incomplete pleading portion of this motion is going to be granted. I honestly don't think any of it's going to be granted. I think it's going to get dismissed. But I'm playing along. Cases, allegations that coworkers caressed plaintiff's foot and hugged her from behind were sufficient to allege forcible touching. That wasn't on the set of a movie, though, was it? Which is one of certain sexual assault claims covered by Adult Survivors Act, People versus Scene, upholding conviction for sexual abuse premised on non-consensual contact between defendant's mouth and victim's neck. Therefore, Wayfarer party's defamation claim must be dismissed because all of Ms. Sloan's alleged statements are an actionable opinion or statements of facts that are substantially true. Wait a minute. It's her opinion that there was a sexual assault, but then they're saying in the same vein but it was actually true. He did do that. Which that is what they're saying. Number one, Sloan was telling the truth and it was her opinion. And if it wasn't true, it was her opinion that it was true. I don't know. It's just I don't buy it. Therefore, must be dismissed. Okay, the alleged statements concerning sexual assault are insufficiently specific. Let's see what law they point to here. Paragraph 193, alleging concerning sexual assault should be dismissed for the additional reason that it is inadequately pled. Paragraph 193, the amended complaint alleged that Sloan escalated the false narrative by telling the reporter that Blake was sexually assaulted. That seems to me a statement from Sloan that Blake was sexually assaulted. All the things that this writer said never happened. As between Miss Sloan and the reporter, however, there was no image capture or representation as to what specific and allegedly defamatory words Miss Sloan said, or when instead, the amended complaint merely reproduces an image of an undated conversation between that reporter and Nathan. That includes the words, and now she's saying that Blake was sexually assaulted. The image of that reporter's text conversation with Nathan embeds an image of his August 8th, 2024 conversation with Miss Sloan and then describes the fact that Miss Sloan did not mention any allegations of sexual assault during their 2024 conversation. The stated claim for defamation, reportedly defamatory statements must be identified with specificity. Specifically, a defamation claim must identify the purported communication, as well as who made the communication, when it was made, to whom it was communicated, case law. Because it is entirely unclear whether the reporter is purporting to quote Miss Sloan, or if he is paraphrasing or offering his own interpretation of different words that she used, or if the she to whom the reporter is referring is Miss Sloan at all. The Wayfarer parties fail to allege with particularity the alleged falsehood uttered. I actually kind of think there's some merit to what they're saying here. And so, like I said, there's one of two different outcomes. Either they're going to beef up their complaint through an amendment that the judge is going to allow if he thinks that it's necessary, if there's not enough here, or they're just going to deny this motion. It's one of the two. But I actually thought that was kind of a fair argument. It could be pled more specifically. Certainly it could. Their defamation claim fails lack specific. Okay, so Wayfarer party fails to allege actual malice. Baldoni is a public figure who must plausibly allege that Miss Sloan made the statements with actual malice. Individuals who have assumed roles of special prominence in the affairs of society and who have invited attention and comment, going back to 1L torts class, are generally considered public figures. As he admits in the amended complaint, Baldoni was the co-star and director of It Ends With Us, which was one of the year's biggest movies. He is the co-founder of Wayfarer and has produced and directed multiple films that were meant to have a positive impact on the world. He played the lead's love interest in television's Jane the Virgin for 5 years. He has a podcast, has written multiple books. He's a public figure. Baldoni is therefore required to plead actual malice to state a claim for defamation. Well, the malice isn't going to be simply that they wanted to get the upper hand in the production of the movie. I don't need to rehash that argument. Wayfarer parties fail to meet the high bar to allege actual malice here. And what are they saying? Must allege Sloan actual malice standard focuses on whether the speaker entertains subjective doubts about the truth of the publication. Conclusory. High bar to allege actual malice. The amended complaint is devoid of any factual allegations that Ms. Sloan knew or should have known that her alleged statements were false. Ms. Sloan was not a first-hand witness of any activities taking place on set, and given Ms. Sloan's long-standing relationship with Ms. Lively, it is no surprise that she credited Ms. Lively's story. The Wayfarer party's conclusory allegations that the Lively party knew the statements were false or had serious doubts about the truth of the statements is insufficient to plead that Ms. Sloan's specific statements were made with malice. No allegations sufficient to allege Ms. Sloan subjectively harbored doubts as to the veracity of her statements, much less non-conclusory facts that support the proposition that Ms. Sloan knew that she was reporting falsities. Like most individuals accused of sexual harassment, it is no surprise that Baldoni has made every effort to confuse the facts and blame the victim, but okay. I would apply the same arguments that I made in the other place where they argued that thing. The Wayfarer party fails to allege special damages. The loss of something having economic or pecuniary value which must flow directly from the injury to reputation caused by the defamation. You mean to tell me that if you are labeled a sexual predator in Hollywood, it doesn't mean that you're going to get fundamentally canceled and therefore being taken out of consideration for future possibly lucrative roles in TV or film or radio? Yeah, I think that I feel like they've met their requirements. But let's hear them out. To satisfy the special damages requirement, the defamation plaintiff must set forth an itemized account. Okay. Itemized account of his losses, round figures, general allegations of a dollar amount or boilerplate allegations. So that is true, but those are things that you usually round out at trial because right now, this is all fresh. We have no data to suggest how his career has been affected by the publication of all this negative publicity. We know what he's made before. We could only speculate what he stood to make in the future. And that speculation is going to require expert testimony. Because he's not going to have, I'd imagine, actual offers from the future that he knows he was going to get offered. And now they're not being offered because of these allegations. So they're going to have to flesh that out. But he doesn't have to do that right now at this stage of the complaints. So he has pled special damages. We just don't know the specifics, and we're not going to get there until we get to trial. So I disagree with what they're about to say. Here, the Wayfarer parties make zero effort to plead special damages. Instead, they offer boilerplate allegations of harm to the Wayfarer party's property, business, trade, profession, and or occupation in an amount no less than $400 million. This is a textbook example of non-specific and conclusory allegations that do not quantify a plaintiff's harm, which sufficiently particularity to identify actual losses. Yeah, there's different kinds of damages. Special damages are speculative but in nature. And he's already pled that he's going to lose opportunities as a result of this lawsuit, as a result of these allegations. What specifically that means, he needs to ferret that out. And so I disagree with what they're saying. For example, actual damages are different. It's like, hey, I totaled my car. I paid $38,000 for that car. I lost out on my $38,000. Plus, I got another $80,000 in medical bills. The actual damages is the calculation of the total of the losses, right? Special damages, speculative damages, prospective damages, they're all different things. Unsupported $400 million figure only confirms the deficiencies in the amended complaint. No, it doesn't. I'm not completely 100% shitting on this argument or on this entire motion. There's some merit to some of it. There's going to be some argument that needs to be ferreted out by Friedman's team. But I think that they know that I think that they knew when they filed this that this wasn't getting dismissed. They got their little PR shot in there. They might whittle down the causes of action related to some of the defendants for sure. They might even get an additional amended complaint out of all of this, but it's not getting dismissed. Failure to state a claim for false light. How are we doing on time? 18. Oh, I did not think I'd be talking about this for this long. A Wayfarer party's false light claim also fails as a threshold matter. False light is not a cognizable claim under New York law. It must be dismissed on these grounds alone, unless they contracted a work under California law, right? Second, the false light claim is impermissibly duplicative of the defamation claim. Yeah, I mean, you kind of tend to lump them all together. You honestly don't need the false light claim. One could argue that false light is an element of defamation. The false light claim is based on the same alleged conduct and some same alleged harms underlying the defamation claim. Must be dismissed as duplicative. Third, the false light claim fails for all the same reasons that the defamation claim fails, which is going to be the same argument and the same retort, so I'm not going to read it. Now, Ms. Sloan and Vision PR are entitled to attorney fees and costs. Upon dismissal of the amended complaint, the court should award fees and costs under New York's anti-SLAPP law. The statute applies to claims that, as here, are based upon any lawful conduct and furtherance of the exercise of the constitutional right of free speech in connection with an issue of public interest. In other words, one of the main defenses to a defamation claim, if you're going to rely on the fact that you were asserting your opinions about the case, is that this claim that I am defaming this defendant or this plaintiff is an attempt to chill my First Amendment rights to free speech. Every state in the country has what they call anti-SLAPP laws, which means there are penalties and costs associated with any attempt to infringe on somebody's constitutional protections regarding free speech. And that's what they're talking about with this anti-SLAPP law stuff here. The statute applies to claims that, as here, are based upon lawful conduct and furtherance of the exercise of the constitutional right of free speech in connection with an issue of public interest. The term public interest is broadly defined as any subject other than a purely private matter, and courts routinely conclude that statements regarding alleged sexual misconduct concern the public interest. Courts have found Facebook and LinkedIn posts accusing an individual of sexual assault to be communications concerning an issue of public interest. I guess unless you know it to be false. And I agree with them. That's going to be a difficult issue for the Baldoni team to prove. But we do not have, in my opinion, grounds to dismiss the complaint yet. They can try again after discovery is complete and they want to bring a motion for summary judgment on some of this stuff. Statements regarding prominent figures like Baldoni also concern the public interest. Under the anti-SLAPP law, fee shifting awards are mandatory, not discretionary. Whereas here, a lawsuit was commenced or continued without a substantial basis in fact and law. Because the Wayfarer party's claims all fail as a matter of law, Ms. Sloan and Vision PR are entitled to recover the attorney fees and costs that they incurred defending against the Wayfarer party's baseless claims. That would be true even without that rule. Dismissal and noting that the demand, okay. Court should strike Exhibit A. Why do they want to strike Exhibit A? So as previewed at the February 3rd, 2025 hearing, the court should strike Exhibit A to the amended complaint pursuant to Rule 12F. The Wayfarer parties filed as an attachment to the amended complaint a 168-page single-spaced document that purports to be a timeline, providing a summarized accounts of the sequence of key events. Exhibit A is an unsigned, one-sided, factual narrative containing selective excerpts of emails and text message with numerous redactions and alterations, including text, underlining, and other annotations. See stuff. Should be stricken as it violates both the letter and spirit of the federal rules. I'm actually not mad at that argument. That's basically what it was. You can't just, okay, so if you have, we're not talking about trial exhibits right now. This is not an exhibit for trial. It was an exhibit attached to a pleading. There's a huge difference. For example, if you admit at trial Exhibit A, and it's this 168-page document that is a Word document full of all of these different weird images, every single one of those images are individual pieces of evidence. And all of the paragraphs contained above explaining what those exhibits would be, individual pieces of evidence would be, is the characterizations of one side of the coin. So you couldn't just say, Your Honor, move to admit Exhibit A. Objection? What the fuck? This is a 168-page objection, lacks foundation, objection, a bunch of stuff, right? You'd have to break all of those exhibits just as a practical measure before we start introducing those things at trial. For example, every single one of the images in that document requires the laying of foundation. One way you circumvent that is putting all these images in one exhibit that gets admitted. And now the images attached within the exhibit are also admitted or part of the record. For that reason, you would object, because lack of foundation. I don't know what that image is. I don't know what this image is. You could stipulate that, but why would you do that? So I actually agree with them striking, well, maybe not striking Exhibit A, saying, fine, we'll just rebrand it as multiple exhibits then. I think maybe in the interest of judicial economy, if I were the judge, this is what I would do. I'll take Exhibit A, but we're going to rebrand it Exhibit A1, Exhibit A2, Exhibit A3, all the way to 168, so that we can have a record of where to point to within the exhibits, understanding that we're not admitting this for purposes of trial. We're just using it for documentary purposes for the record. Because when they get to trial, that's not going to go on their exhibit list as Exhibit A, this 168-page document. I promise you they're going to flesh that out a little more. Rule 8A requires that a pleading contain, I lost my place, a short and plain statement of the claim showing that the pleader is entitled to relief. Where am I at with this? Oh, the principal function of this rule is to give the adverse party fair notice of the claim while avoiding placing an unjustified burden on the court and the party who must respond. Consistent with Rule 8A's requirement of a short and plain statement, courts may not properly consider for their truth statements contained in exhibits attached to pleadings. Except, I think they'll probably make a concession that we're not offering this exhibit for the truth of the matter asserted. They're offering it for their impressions. They're offering it for their opinions, understanding that we're not a trial. This is not an admissible thing just yet. I think they're putting cart before the horse. While Rule 10C provides that a copy of a written instrument that is an exhibit to a pleading is a part of the pleading for all purposes, a personal narrative summary of experiences and events does not satisfy the definition of written instruments. Rule 10 protects a defendant's entitlement to know the allegations against it and have those allegations framed in separate paragraphs. Oh, they're talking about, well, they have in the pleadings. The exhibit never purported to be pleadings. That's their characterization of their own pleadings in their own timeline. I think that's well understood. The pleadings stand for themselves. The pleadings were pled under oath. The exhibit was not. I think we already have those protections just by virtue of the federal rules. And we're not at trial. This is not in front of a jury. It is an attachment to a petition that we understand the Exhibit A is not offered for the truth of the matter asserted. It is a collection of pictures and photographs. It could be akin to an unverified declaration, not offered for the truth of the matter asserted, but offered to assist the court in understanding the merits of their complaint, which would fly in the face of what they're arguing here, that the defendant has a right to understand the allegations made before him or her. Well, look, not only do you have a well-written complaint, but you got this exhibit that kind of puts it in perfect framing. Isn't that not what you're asking for? Why should I strike it on those grounds? Again, I wouldn't strike it. I would chop it up a little bit is what I would do. With an understanding that this exhibit has not been offered for the truth of the matter asserted. 12F authorizes courts to strike any redundant, immaterial, impertinent, or scandalous matter. Well, I don't think that you could just say it's scandalous. The majority of those 168 pages were highly relevant to the causes of action in the complaint. Certainly not impertinent because it was relevant. Certainly not immaterial because it was relevant. Certainly not redundant because it was a 168-page timeline going step by step about how we got from A to B. Redundant is in it repeats some of the stuff in the complaint, but that's what exhibits do. Exhibits in complaints are supposed to give credence to the allegations made in the moving documents. They continue with Rule 12F. When a complaint does not comply with the requirement that it be short and plain, the court has the power to strike any portions that are redundant or immaterial, but that's limited to the complaint, I believe. You don't go striking individual exhibits for that. Exhibits are not held to that standard. court may also strike information that is immaterial and irrelevant. Yeah, you said that already, and I disagree. As the court noted at a February 3rd hearing, Exhibit A is almost exactly the type of document that the federal rules are designed to prevent. It violates Rule 8 because it is neither short nor plain. It does not provide fair notice of claims, and it places an unjustified burden on the court and the parties. Did they say that at the hearing? So that noted at the hearing. Somebody made that argument at the hearing. And I guess maybe they took it under submission. Maybe they said, you know what, file a motion. And this is the result. We're getting this motion. All I'm saying is they're saying, as the court noted at a February 3rd, Exhibit A is almost exactly the type of document that the federal rules are designed to prevent. But there's exceptions, I guess, is what they're saying. So, and I guess it probably goes to the argument that you have this 168-page document. Every single one of these images, text, and exhibits can be broken up into individual exhibits. And so is it more burdensome for the court to have this as Exhibit A, or would it be more burdensome to the court to have this as Exhibits 1 through 168? I don't know. I guess they got to decide, because it's certainly not repetitive. They are exhibits meant to bolster the pleadings. And so I guess we'll see. Exhibit A violates Rule 10A because it is not a written instrument, but a personal narrative summary. It is. But I think because it's a personal narrative summary, it's harmless. We understand it is a characterization. It's not triable evidence. It's not admissible evidence. We get it. I just don't see the purpose. Even if they got it dismissed or they got it stricken, it's still permissible as a website standing alone, as an opinion piece that was put out there by Justin Baldoni's legal team. Anyway, in conclusion, dismiss the complaint. What have we got here? What's at the bottom? Oh, that was it. Oh, good. Woo! So, let me get rid of that. Well, folks, that is the motion to dismiss. What do I think of that? I think that it's probably going to have the effect. Number one, I don't think anything's getting dismissed. I think that you might have some of the causes of action whittled down, possibly, against 6 of the 7 named defendants in the case, unless the court buys into my agency argument, which gives rise to the possibility that they may not. I don't get it. I don't think it's getting dismissed. At best, it's getting amended somehow or bolstered somehow, but it's not getting dismissed. So is it a big nothing burger? No, it's not nothing. It's litigation. Somebody paid like $15,000 for attorneys to write that motion. So it wasn't pointless. It is going to have the effect of, I guess, marshaling the evidence. That's what we're supposed to do in civil litigation. So it wasn't a complete waste of time. It was way better written than Lively's amended complaint, for sure. Hey, Kai. Oh, look at that. I got super chats. Kai, thank you so much for the 279. I appreciate you. You've been amazing in the comments, by the way. I've been noticing you as a regular, and I appreciate you being here. Zawaki, man, how you been? I miss you, man. I hope you're doing well. Thank you so much for the 5 guilted lawyer memberships. 5 tilted lawyer memberships. I appreciate you, sir. And then coming through with another 5 and another 10. Zawaki, you're a G, man. Hey, we gotta do a thing together pretty soon. We gotta do some things. Thank you so much, Mariah Escobedo, for the 5. Would her forcing them to recommend a PGA credit under duress? Yeah, that was kind of exactly what I was getting at. Like, yeah, there wasn't tangible property, but there certainly was credits that were being threatened to get taken away. And that's exactly what I had in mind when I was making that argument. So yes to that question. And thank you so much again for the 5. Folks, that's all I got time for today. I did an hour, 34 minutes, which is 34 minutes than I had planned. I got to go do lawyer shit now. I love you all. I may see you later on tonight. Love you all. Bye-bye.